Hi, good afternoon, everybody. Thank you for inviting me to speak. I'm a new face to many of you here today. I joined NPCC just recently, so I'm new to NPCC and I'm new to policing. And I'm sure I'm going to be calling on many of you here today in the future to help me build that understanding of policing. But what I'm not new to is police pensions and pensions. I've been working in fire pensions the last 7 years, but I've also been working very closely with my predecessor, James, on police pensions. So I have a very good understanding of the challenges that we have ahead of us. So the presentation that we've built today is to give a very brief insight into what we believe some of the challenges about pensions look like and how we believe that there are the inroads that we need to make to overcome some of those challenges. Of course, pensions I could talk about for days, for hours, and I'm going to have to make sure that I'm very brief today about some of these issues. But where there are more detailed issues, please do ask me questions, and my email address is at the end of the presentation. So what we're covering today is a brief look at how some of those challenges are addressed and introduced by the age discrimination remedy and the bill that is the legislation that looks to achieve the results to the remedy. We're going to look at how we can meaningfully engage on what those challenges look like and how we can get the answers that we currently seek, what that might look like and what that might mean. And then in particular, we're going to focus on the communications challenge and how that impacts on the workforce and how we're utilising technology to overcome and de-risk some of that communications challenge that faces us. So to start with, just an introduction around what the bill, so what the legislation and what HMT are currently trying to achieve. So remedy still started, of course, with the court cases and being involved in Sargent, I had the pleasure of sitting in the courts for all those cases. And as that came to a head, government then had to consult over what they were going to do to remove that discrimination that existed in the schemes around the transitional protection, so the discrimination that treated people differently based on age and kept some people in the legacy schemes and some people in the new reform scheme. Of course, it was found to be discriminatory and they had to remove that discrimination. So what the consultation looked at, and the consultation response was published earlier this year in February, and the consultation had looked at how can that discrimination be removed. And they consulted with regards to removing the discrimination going forward, which was called the prospective, and retrospective going backwards. How did they remove the discrimination that had actually happened to people? And government said in their consultation they were going to do that by introducing, for the retrospective, something that they were terming the deferred choice underpin. And we'll look at how that's achieved in the bill and the challenges that we think that currently looks at. And for prospective, they said they were going to remove that by putting everybody into the reform schemes from the 1st of April 2022. So recently, the bill, the sort of the legislative path to do that has been introduced, and it's currently working its way through Parliament. And so to a large extent, it does do what the consultation said they would do. It introduces that DCU option for the retrospective remedy, and it removes the discrimination going forward in the prospective. And the bill sets out that that's going to happen over 2 different periods. So prospective, the bill sets out the commencement date as the 1st of April 2022. And that has the effect of putting all members of the current pension schemes into the reform schemes, the 2015 scheme, going forward. And then the retrospective looks at dealing with what's called the remedy period from the 1st of April 2015 to the 31st of March 2022, how that will be rectified and remedied. And what that does is it returns people to the legacy scheme, so it treats everybody the same. So that's what the bill sets out to do. And as I say, we'll look over the next few slides at the challenges that we currently think that there are with regards to achieving that, how that will eventually look. So the prospective remedy, largely legislatively anyway, is achieved by 2 clauses of the bill. 76 and 77 for those who are interested in bedtime reading. But what it particularly does is it removes the original protections that were given to people based on age from the Public Sector Pensions Act 2013 And again, it's Section 18 is the specific part that it removes. So what that does is it stops anybody being able to be part of the legacy scheme going forward that were originally given that protection under the bill. But it only removes that protection. It doesn't remove what was called the transitional protections that were given to members. So it introduced a new concept of a member called a transitional member. So a member who had essentially 2 foots in 2 camps. One has past legacy scheme, and then you move into the 2015 scheme. And it gave certain protections to how those benefits would work in the old legacy scheme. And so the bill doesn't remove any of those protections. It doesn't remove the right to a final salary link. So when somebody retires at the age they were always going to retire at, they can still retire for their final salary benefit based on the salary they have at retirement. It doesn't remove some of the criteria and the eligibility under the 1987 scheme, such as the right to retire at 30 years of service, and that 30 years of service still includes both 1987 plus 2015 service. It doesn't remove the right to actuarial commutation factors. And it doesn't remove the right to what was called the weighted accrual, the double accrual guarantee, that gave a guarantee of the way that the scheme previously worked. So the effect of the current bill and what the government wants to take through at the moment has the effect that all members will move forward as a member of the 2015 scheme from the 1st of April 2022. And it essentially doesn't change the position of transition members since the schemes were originally introduced in 2015. So it doesn't remove that protection. But what the bill doesn't currently deal with either is the effect on retirement from the 2015 scheme. And this is something we've heard a great deal about recently. So while the retirement age from the final salary scheme is still protected, and somebody would still be able to go at the age of 30 years, so that could be at age 51, that has an effect, however, on their corresponding 2015 scheme benefits, where it means that the person is then treated as a deferred member, essentially a frozen pension under the 2015 scheme, and they are treated differently in terms of how the actuarial factors might be applied to a member who would be currently retiring at age 55. And that's something at the moment that we all watch to consider and see how that's going to be treated under the bill. And it's certainly an area of concern. So moving forward to look at what the retrospective remedy and how the challenges look like there, particularly, as I say, the challenges for the questions that we currently have. So before we just have a look at the bill, we can just think about for a moment about what is it that the retrospective remedy does. I talked about the deferred choice underpin, and it works in 3 sort of distinct ways. So what it does is it puts everybody back into the original legacy schemes during the remedy period, but it creates a choice for a member. So you have to then create what's called an underpin. You create exactly how those benefits have looked like during that remedy period in case they are better for somebody to choose. And then finally it allows somebody to offer, to make a choice at retirement. And one of the reasons why the choice at retirement was given rather than what was called immediate choice was it was recognised that making that choice could be difficult. It could be confusing. There can be lots of different areas to consider when making that choice. And the idea would be that people would have facts and figures in front of them instead of guesswork. But to bring in that choice introduces the most overused word in legislation for a while, complexity, complex. We're all talking about, the complexity of what it is we're trying to achieve. And the complexity and looking at the complexity is useful because it allows us to then look at what we're seeing from the bill. Has any of that complexity start to be unravelled? So when we talk about complexity for DCU, what is it that we're actually referring to? So first of all, we talk about that conversion to final salary. So that treating the period from the 1st of April 2015 to the 31st of March 2022 as if it had happened in the final salary scheme rather than the reform scheme. And what we need to do with that is take all of the activity that may have occurred in that time and do something different with it. So somebody might have had a transfer into the reform scheme. Somebody might have made a pensionable pay choice that would have a different effect in the final salary scheme. Somebody might have bought some added pension because they thought that they weren't going to achieve the same amount of pension as they thought they were. So there are lots of choices that people have made. Some of those choices they wouldn't make by returning into the legacy scheme. Some of those choices they still would make, but the legacy scheme doesn't actually have parity and give you exact pension for exact pension. So there are a number of unanswered questions there of how that would be treated. So that's one of the first things we were looking for in the bill. The second thing is to be returned to the legacy schemes involves actually having to adjust the contributions that somebody would have paid. And under the 1987 scheme, somebody would have paid more contributions, so that member will owe money. Under the 2006 scheme, they'd have paid less contributions, and they would owed money back. But in particular, we need to consider the impact of the tax system and tax relief on contributions. So under HMRC, contributions when they're made are paid net of tax, so you get tax relief on it. And that has to be adjusted as well in that refund or that overpayment. And we were looking to understand how government were going to treat that. And then sort of taking the last two together, the sort of calculation of pensions growth and tax. Now, tax only occurs if you've gone over the pensions growth in the first place. But what has to be first found out for every single member returning to the final salary schemes for that period is a calculation of that pensions growth. Once that has happened, you have to determine whether that person has actually now has gone into the tax limits and has tax. And of course, that may affect, they may have already paid tax, that may be additional tax. And so there are lots of questions that we have with regards to how does that work? When does that member pay that tax? And in particular, the HMRC system works for the last four statutory tax years, whereas the remedy period is 7 years. So we have a period of adjustment there that we need to understand how can that deal with 7 years worth of tax adjustments. So they were some of the things that we were looking for when we saw the bill and the clauses in the bill. So I'm not going to go through all the clauses of the bill because we'd be here all day, and I'm going to pick out a few of them that answer some of those questions. The first couple of sections of the bill, so clauses 1 to 11, generally achieve that DCU. They set that remedy period, they put the member into the legacy scheme, and then they allow them to make the choice at retirement. Clauses 13 to 16 are where we start to see some of those questions creep in around contributions, and I'll focus on that in a moment. We then move on to the later clauses of the bill. So 17 to 20 in particular start to deal with some of those technical questions that we just talked about that activity that's happened between 2015 and 2022, where somebody may have had a divorce, where somebody may have chosen to have paid tax by scheme pays, where somebody may have transferred in. Clauses 21 to 22 are incredibly important because they're the bit that confirm around the compensation. So what happens when actually you can't have the pension? What happens if the member says, well, I wouldn't have made that choice in the first place? How do we rectify that for the member? Because the two periods are not sort of like for like. There are other clauses in the bill, but I'm not particularly going to focus on those today, but I was just going to pick out a few. So, of course, clauses 28 to 29 recognise the concept of immediate detriment. This is where people are already retired from the scheme. And what that does is it recognises that position and it stops any double recovery. So where people are put into rectified immediate detriment, it allows, once the legislation is in place, for that to come through and be rectified. But as I say, I wanted to just focus very slightly on the couple of areas that we think at the moment are still concerning and where we're not, don't currently have the detail we would like. So as I say, clauses 13 to 16 deal with that contribution adjustment. And in particular, sort of taking that backwards, clause 16 is particularly interesting to us because what clause 16 tells us is that to achieve that adjustment to the tax relief that I talked about, HMT are planning to go outside the current HMRC processes and create that so it's net. So the member pays net contributions free of the tax relief that they either would have received. So they're paying less contributions. But what we don't know at the moment is the mechanism of how that would be achieved. So we have the detail. We have some of the mechanism. We understand that HMT are doing that to make sure that everybody is treated exactly the same way they would have been treated if they'd made that contribution at the time they should have made it. But we don't have the specifics that allow us to actually understand how to calculate those contributions if we wanted to do that now. We know that there are various different times to do those contribution adjustments. We know that members basically at the enforced date, Clause 14 tells us that people will have to pay their contributions at that date or receive that refund. But what the bill doesn't tell us is what kind of time period members would have to pay those contributions over. And we don't know at the moment whether that would be a Treasury direction and how much influence we would have over that, or whether that's going to be a Home Office regulations, and again, the kind of influence we would expect over that. Now, we'd expect more consultation with regards to Home Office, and we'd expect that to look at the Scheme Advisory Board around what is a reasonable time period to allow people to pay their contributions. It talks about the rectification challenges, and in particular, I'm picking out the clauses there in red. So Clause 18, which allows potentially some form of choice exercise where additional payments have been made and the member may say, actually, I didn't need to pay them now. We need clarity on actually, if that's some form of choice, who exercises that choice? Who decides whether that member's going to have that choice or not? Is that potentially going to be the scheme, the responsible authority, the Home Office, or could that come down to individual scheme manager discretions? These are really important areas that we need to know. Clause 20 in particular is a very wide catch-all for a number of areas that are of current concern, particularly around what we call contingent decisions as well, where somebody might have made different decisions. It also provides powers for taper members. So we really want to know the detail. At the moment, the clause is very wide and again refers to Treasury directions. So we need to understand more about that, to understand how we can influence the detail so that we can then start communicating that and understand whether that achieves what we need for policing or not. And finally, I was just going to touch on the compensation clauses, which provide confirmation that there will be compensation to member for what they call compensatable losses. And it does go further than that, and it gives us some descriptions around some of those losses, particularly tax losses. So it says that where people have lost out on tax relief, or pensions tax, unauthorised pensions charges or otherwise, specifically because of the mechanism of the remedy, the member will be compensated for. And so we welcome that clarification. But as yet, the wider losses, other losses are yet to be defined, and we don't know what would be included in that. Specifically, we don't know who would help define that. And again, is that to Treasury directions and the granular detail in understanding the influence that we'll be able to have in ensuring who and what is included in those losses. And importantly, we don't have confirmation on funding either. The bill is currently written so that the employer, the scheme manager, provides that compensation to members, which is in essence the employer. So I'm just going to finish now after a couple of slides where unfortunately there's a lot of don't knows and there's a lot of challenges about how we're going to move forward, particularly in engagement. And the slide there illustrates what I often refer to as my pillars. And I believe we need to build these pillars up before we can start building a more stable background to actually understand pensions and to have the pension scheme as we'd wish to actually see it. In particular, each of those areas are very specifically important to members and the understanding of pensions. Now, Nick is going to talk a little bit more about the importance of communications. But we can't underestimate enough just how important, I emphasise, how important communications are, particularly on workforce decisions and choices. And we are very clear that we have a big programme of work ahead of us of how we can work with the sector to understand what that challenge looks like and how we can overcome it. We're also clear that the way the scheme is structured, the local administration nature of it, the fact that each chief constable is a scheme manager and has decisions over who they appoint for administration and software, creates some difficulties with regards to getting consistency. And we want to work in that sector to understand more about how we can drive more collaboration and uniformity and therefore consistency to every single member experience that we can. The regulations, we've already talked about a number of the challenges that we have, and again, we will look to engage further and understand what those challenges look like, and we open ourselves to that engagement and conversation. Peer working and best practice groups, well, that happens everywhere, doesn't it? You have to have that. You have to be talking together and understanding how that influences different people at work. And then finally, really importantly, and I would say around effective governance is important to me because I've spent the last 7 years being secretariat to the Fire Scheme Advisory Board, and I've seen the difference that good governance can make at both local levels and national levels about holding the scheme managers to account and understanding actually how different decisions are made locally and that they are taken with regards to both the scheme rules and what we want to see achieved for members in particular. So Nick is now going to take us through particularly how we're going to achieve on that first pillar, communications. So thank you very much for your time, and I'll finish the session after Nick has spoken. Thank you.
Thank you, Claire. Recognising that much more complex arrangements that Claire has just outlined, I wanted to take a little bit of time now to look at how we can best communicate the changes to members. Firstly, we need to recognise that individuals have different requirements in retirement. What someone needs will be determined by things like age, health, family commitments and desired lifestyle. Once you've established what you actually need in retirement, you consider how it can be funded. Obviously, the pension will be expected to meet a large proportion of that requirement. And in planning for those needs, the 1987 scheme was fairly simple. Work 30 years and get 2/3 of your pension. Very straightforward and easy to see how it can impact on your retirement needs. So one of the biggest challenges that we're facing is how can we help people understand how moving to mixed benefits will impact on their retirement planning. Understanding how care works is, to use the word again, complex and requires each year to be calculated individually. We've not had to consider things like CPI and revaluations before. So getting an accurate estimate will require more than a pen and paper with a late-turn van driver, as I think I did in my career. Also, how do you now model your career? I'm sure we all had aspirations when we first joined about what rank we would reach, but I'm not sure many of us have achieved each rank at the time we expected to achieve that rank. And this adds to the difficulty, because the longer you're going to be in a rank, the more income that you will get in retirement. It's also important to highlight, I think, some of those common myths. We've heard a lot of stories that people are looking at opting out altogether from pension schemes. Now, we know that there are penalties for doing that, so part of our communication is to ensure that we are highlighting those difficulties to individuals. I mean, the scheme may not be popular, but irreversible decisions will need careful consideration. Now, it is, I think Claire already mentioned, there are benefits in remaining in that 2015 scheme. And those who do continue in the 2015 scheme will protect benefits they have already built up. And this includes the final salary link, normal retirement age, and weighted accrual. So looking at those in a bit more detail, this is our first order of priority, is to help members understanding how schemes work together and how those protective features operate. Weighted accrual for those from the 1987 scheme will help to preserve the proportion of pension that you would have got if changes hadn't happened. And the final salary link is important as it maintains the preserved 1987 pension is going to be based on your final salary when you retire rather than when you defer the pension. And you'll still be able to take your legacy benefits at your normal retirement age, whether that's 30 years or age 50 or age 55. And it's important also to bear in mind that in the meantime, you will still be building up benefits within the 2015 scheme. And actually, albeit it's not popular, it is still a fairly good scheme compared to others in the market. However, it's important to point out the benefits are not available until at 55 at the earliest, and then they come with a hefty actuarial reduction. So helping members understand how these benefits work together is where we're looking to concentrate our efforts. We are working currently with the Government Actuaries Department to fund a calculator that will allow members to insert their details and produce meaningful information about their pensions, showing the impact of things like the weighted accrual and the actuarial reductions. We're also working to produce member scenarios which provide a visual representation of benefits. However, I think these will always be fairly limited and generic. It's the pension administrators who need to be able to provide the bespoke illustrations, which will include other details such as the tax implications that we mentioned. So much of our attention is currently on the software suppliers and the administrators to update their systems to allow the members to obtain the individual illustrations. However, we need further clarity on things like the tax implications and the treatment of contributions. So this won't be a quick fix. There's still work to be done. There's still a lot of unknowns that we need answers to. But what we are trying to do is working to provide that clarity to members. So I think that covers the communications part. And I'll pass you back to Claire to finish up. Thank you very much.
Thank you. So just to end our session today, we just wanted to reiterate some of the key messages of our presentation around we believe that open engagement. Pensions can't work in isolation. It's not something that can sit on its own. It has to work and understand the workforce implications and the employment implications of that. And to do that, we need to work together to understand that and to understand how that implicates for individual members. And we are very genuine when I open up that open engagement, and we do wish to receive information and comments about that. We wish to be constructive partnerships. Somebody talked earlier today with regards to being a critical partner and how partnerships, healthy partnerships, work well when you can be a critical partner. You can respect each other's position and agenda, but still work together and ensure that it doesn't become adversarial. And in particular, we really want to work to focus on how we can build better governance, really good governance of the pension scheme so that we understand what the challenges are, and more importantly, that we can deliver together what those solutions are going to look like. So I really enjoy and looking forward to working with this sector going forward. And the next 2 years are going to be challenging, but I am really looking forward to the challenge. So thank you very much. Our email addresses are there for you to be able to contact us if you'd like. Thank you very much.
Yeah. Okay, I think we're ready for questions. And we've got lots of them, as you would imagine. Absolutely loads. But first, though, I think we've got to hopefully get Matt, who's going to join us. There we go. As if by magic, it's all worked. Okay, so we have our complete panel. Matt, can you hear us?
I can, loud and clear. Good afternoon.
Afternoon, and thank you for joining us. So I've got lots of questions, so I'm going to go with the most popular ones in that sort of order. So we'll start with this one, which is quite simply, it's quite clear that the current police pension providers and in-force pension teams are not going to be able to deal with demand for colleagues' different pension forecasts, and for some this will cause further uncertainty as they'll have no idea what they need to pay in back contributions, tax, before even considering their benefits. Is this on the NPCC risk register?
Matt, go on.
Shall I?
Yeah, go on.
Yeah, please. Yeah, I'll take that one. So I think overall, in our assessment of workforce risk, the impact of the pension remedy is clearly present. We're concerned about that from a number of perspectives. There are some wider financial concerns for the service as a whole, And there are concerns, obviously, at a workforce level and for individuals. For us as leaders, I'm sure Martin would echo this. You know, we are all very, very concerned about the impact this makes on individuals and their choices and their confidence to come to work and stay at work and do the brilliant job that they do. So on the very specific question, I think it's been picked up two ways. The first is there is some Home Office funding to support the central work on this, and also the capacity for us to distribute some of that money into forces. It's £7 million we've received, and so that is pushing its way through in a number of ways. In particular, to get to the second point, we're really concerned to try to get the most effective modelling tools we can so that people can understand their own circumstances accurately and get the best information that they need. So we are contracting with the government actuarial services to provide a modeller to do that, and that will be the kind of online calculator colleagues will recall from previous pension reform. But to the core point, there is no question that this is going to place a pressure on local capacity to provide information. That's why that Home Office funding is important, and that's why we need to keep playing forward to government that the earliest access to good information about the way that these specific changes will impact is critical, because all your in-force teams need to process that, of course, with the support of a central team. And I think the final thing I would say in terms of mitigating the risk is I'm grateful to colleagues, chiefs across the country who have gone into their own resources to provide support for a central team. You've heard from Claire and Nick, and you can see how expert and conscientious they are. But we really do need that ongoing support to make sure we do as much of that work centrally.
Okay, so just to clarify, there is £7 million in a pot, basically, and that will be available for people, well, it will be used to provide information so people won't have to contract private people to find out more about their own particular pensions.
No, no, and I should be really clear on that. So the first thing that money will do is help us provide as much support from the centre as we can, as much support to provide things like online calculators and the tools which will give individuals estimates or calculations which they can then take into getting personal advice. So work at the centre. The second element will be to distribute some of that money to forces to try and support local efforts to make sure pension teams have got the right capacity. And what we won't do, though, and what won't be available is at this stage is a pot of money in the way you described it to go to supplement for individual advice. We still think it's likely that, particularly with the tax implications, some people may want to and potentially feel they need to take individual advice. What we want to do is make sure that when you take that advice, you've got the best possible and most accurate information from your scheme manager, from your force, and from the NPCC's central team.
Okay, well, a question that comes naturally off that then, it's a really popular one, and it is quite simply, I'm recalculating all of my tax, it's beyond me, will I receive compensation or a rebate for any cost I incur employing a specialist?
I'm going to turn, if I can, to, I'll open on that one, and I'll turn to Nick and Claire to say a bit more about, unfortunately, the long lists of questions we don't have answers to at the moment. Okay. The first thing to say is there is an enormous financial implication from the pension reform when you take it up to the level of the forces and across England and Wales. And we have no reassurance at this stage that those costs are going to be met centrally, and that is a real concern for chiefs across the country, for Martin and for colleagues, because we don't know how overall compensating people for the discrimination that has been conceded and found will be met. We don't know how plugging the gap in pension contributions to make the schemes viable will be met. So it's not easy for chiefs to make further commitments at this stage in terms of meeting any costs directly.
No, okay, we understand that. We can see the concern, though. So I just want to, you said perhaps Claire could talk a little bit more about that.
that particularly there is what we don't really yet understand is what the provision on compensation in the legislation means and how it would be financed. And so I'm laying the context out. I think we've got to be very realistic with colleagues. There is a real financial risk around forces, not easy to make commitments lightly. We have got reference to compensation, and I would hand to Claire or Nick on that.
Okay.
So as I referred to in the presentation, Clause 20 does refer to other losses, and it is possible that those kind of other losses and compensation for those kind of could be included in that. But we are pushing to understand the detail, and as Mr. Jukes rightly says, we also need to push to understand who's going to be responsible for financing that. The way the clause is currently written is that that's scheme managers who are going to provide that compensation to members, not central government. So we really need to understand the financing before we can understand more generally and understand where we need to push for other losses to include. So I know that at the moment it's disappointing that we don't have that detail, but that is as far as we have at the moment. And that funding issue really is very important because, as I said, it could end up being funded by the employers.
Okay. Yeah, sure.
The scheme managers are the chief constables. Chief constables are the respondents in the legal claims. So really they shouldn't be involved in deciding compensation because they wouldn't be independent.
Can we get you on the mic, please, Dan? It's just we're getting bits of what you're saying.
Sorry, scheme managers are also the respondents to the legal claim. So if in the legislation the Treasury are putting scheme managers as those responsible for the compensation, I think that would be legally challengeable in itself because it wouldn't be seen to be independent. Scheme manager, Matt, for example, with a force who's got other commitments, is going to look at something and say, I can't afford it. That wouldn't be a fair process. So are you feeding back to Treasury that, again, the police service is scheme specific and the bill isn't catering for things?
I mean, if I can deal with that, Dan, thanks. And can I just say, because I know you've got hundreds of your members there with you, that thank you, Dan, for all your engagement and support. I got a few more grey hairs since that engagement and support started, but you know that you've got an open channel and you've been really diligent and dogged on behalf of your members, and I, you know, they need to hear that, and I know will appreciate it. You've also got a great body of knowledge, and I think it's worth saying that the staff associations, Superintendents Association, and the Police Federation are really important contributors to government's perspective on this, and you should continue to take your opportunities to influence government. You have probably as many conversations with ministers as we do, but we don't duck our responsibility to do that, Dan, in answer to your question. These reforms were not designed by scheme managers, by chiefs. They were not they were implemented, in our view, as a result of government policy, and therefore we take every opportunity to remind government that the implications should sit there, including financial implications. We are not going to duck from trying to take care of people in that process, but we actually, I think, have got common cause in trying to get as much central activity in what is otherwise this dispersed system, which is, as you know, you're closer to this than many of our colleagues. This is a very unusual sector because of the way the schemes are pushed out to local management. So, long answer to say thank you to you, Dan, but secondly to say yes, we keep pointing out that policing and the police pension scheme is a different animal than most of the schemes in the public sector that have been reformed.
Okay, I'm going to rattle through some of these questions because I think they're all really important, but this one is, do you think part-time officers will be discriminated against in respect of the pension changes?
Unfortunately, I'm going to have to give it... Sorry.
Well, I'll tell you what, Matt, do you mind if Claire takes this one and then we'll come back to you?
Thanks, Claire, yeah.
I was going to say, unfortunately, I'm going to have to give a disappointing answer of taking that one away at the moment. While my 7 years in fire has been dealing with pensions, we didn't have many part-time, and I was only speaking to Dan the other day that I need a while to get my head around the part-timers. So unfortunately, I can't give a clear answer to that today, but it is something that I am determined to understand more fully, and I can come back to Dan with an answer.
Okay.
Can I just respond to that slightly as well, to say that one of the things that we're really concerned about is the quality impact, not least of which we are responding to discrimination from a reform, and to some extent we've been encouraged to give a view on that point, to give reassurance, if you like, on that point, and I don't think we can. I think it is the responsibility of those who are going to legislate in the first instance to make sure that we properly equality impact the reforms which are following through and the remedy which follows. So it's a very important question, and if there are case examples or illustrations which tend to suggest you can see the potential for discrimination, then the Home Office and we need to see that, because clearly it would be perverse to replace one form of discrimination with another, and as chiefs we are keen to avoid that, but we're also keen to avoid giving some kind of blanket assurance which we're not in a position to.
Okay. What's the impact of being a transferee into the care scheme and retiring before the age of 55, and is the impact, in your view, fair? Can I?
I can't see colleagues in the room or our moderators, so I'm gonna let you guide that to somebody.
It's difficult at the moment to comment on that without understanding more about what's been looked at, and in particular with regards to taking legal advice on it. It certainly seems to be, at face value, perhaps disproportionate that members who are 55 are under 55 when they get to their protected pension age by virtue of the transitional protections would be treated differently. But at this stage, I think it's we can't really give a personal view about whether that's legally fair or not. We do look to uncover more about that and to develop a position on that as we go forward, and we're certainly engaging with Home Office and HMT to understand their views and what they might be thinking about doing about that. So it's something we're going to take away.
Okay. I'm sorry, we seem to be giving you a long list of things to take away and come back to us, but another quick question, equally important. I retire before October 2023. I am not a protected member. Will I be retired on the correct pension?
Shall I just, I'll open up on that if I could.
Yeah.
Very briefly just say in respect to the previous question as well, I think it's very clear government take the view that moving to an age-based scheme is fair. Government take the view that moving to an age-based scheme is fair, and of course age-based schemes exist across pensions and across the public sector. So that is a question that really needs to be tested, because what we'll have is people who are on both service-based and age-based pensions, and there'll be an interplay between them. So it is probably the million-dollar question really for a lot of people sat in the room, which is also then your transition group. And in replaying that, can you just repeat the question slightly for me so I can just check that I respond to the very specific point?
Yeah, just bear with me because it's gone. Once it's asked, it's gone. So we'll get it back for you, but I'll see if we can get it back quickly, actually. I will come back to you on that, Matt. Just bear with me.
I'll jump in, because on the question of the October 23, which was the core of it, wasn't it?
Yeah.
So I think this goes to the point about both. So there are people retiring now, and they are subject effectively to this group known as immediate detriment, and in some instances are being treated as if they've been returned to their original scheme, and that's the immediate detriment approach, which is effectively being done on a case-by-case basis across forces. We are concerned that group will grow from April 22 to October 23 as people leave the service without those adjustments having taken place, and it will be thousands. It will probably be the 6,000 or 7,000 people who retire from policing every year, as I recall the numbers. So The reality is, and it's something just for people to, I think, for us to work with colleagues to prepare themselves for it. Is it possible that people will retire, and that in the period after their retirement, a year or two after their retirement, the kind of adjustments we've talked about, contributions and taxation, will still be taking place. So that very neat moment that people have experienced previously of receiving their certificate and receiving their pension and walking out the door knowing that those benefits are as defined, that may not take place. And I think we all need to, we do need to be realistic about the challenge of being ahead of that by April 22, because there are so many unanswered questions from a government perspective. We may see a reality of colleagues retiring and those changes taking place after their retirement date.
Yeah, I hear what you're saying, Matt, but it wasn't what people signed up for, was it? And just to reiterate, that question was about being a protected member and being retired on the correct pension. So I think you gave us the gist of that. You mentioned dates. How do you propose to get all the pension changes ready by April 2022?
Can I just respond to your point about the moral contracts, which one could take a view on, and of course, what we want to do is recognise that these are government-wide reforms. We have played forward the impact on the workforce, the morale impact on the workforce, and been very plain. So I wouldn't want anyone in the room to be left with the sense that we are advocates for any of these reforms. We are bound to now work through them. I am not sure, and I'm being really candid here, because people need to make their plans accordingly. I am not sure that we will have the answer to every question. In fact, I'm relatively sure we will have unanswered questions by April 22, and that people will still be having to understand and test what the implications of these changes are for them in the year or two that follow. What that means now for people, I think, and I'm absolutely not going to give anyone financial advice based on this difficult set of circumstances, but that I would really, the one thing I would say is I'd urge people not to make decisions in haste, not to feel the sense that we recognise and see of people's feeling about a broken moral contract, if that's the way you would describe it, not to take that emotion into a decision that could really impact on your long-term future. So as Nick has described, you will still accrue valuable benefits potentially by staying in these schemes, and should really take care. But I wish I had an answer which was, we'll get all this done, you'll have fantastic access to information and be able to make your personal choice by April 22. And we want that to happen, and we want that date to be as close to April 22 as we can. And that's why we've got good people working on that, resourced from forces and, of course, in forces.
Okay, no, I hear what you're saying, Matt. I apologise if it comes across that we're giving you a hard time, but it is just genuine questions.
I expect a hard time on this topic.
Yeah, okay, fine. All right, well, carry on with the hard time then. Can you confirm that protected members were given a promise that they will stay in the 1987 scheme until they retire?
Can I just check? I'm gonna pass that back. I don't want to give anything which is less accurate, so let me pass that back to Claire and Nick.
So I can only comment on what's in the regulations and what the government set out. I can't comment on wider than that. So in 2012, when the government first consulted on bringing in the reform schemes, and they set protected pension age, and they set a protection for people aged over a certain age before 2012, they were given protection via the regulations. And it was the challenge, it was the court that said that giving those people those protections was discriminatory. So giving somebody a protection based on age and keeping people in the final salary schemes was discriminatory, and the court said that you couldn't do that. So the regulations are being amended to remove that, and therefore removing those protections for those members. So we can only comment on what the regulations say. We can't comment on wider conversations or potentially political conversations that were going on at that time. But the regulations are being amended via the bill, which removes that protection from the 1st of April 2022.
Okay.
But can I just,
Yep.
we might make sure, perhaps with Dan, we circulate something on that point specifically, because I think what I wouldn't want to unnerve people by is any thought that they will, effectively, if you reach 30-year service before April 22 and would have been fully protected, you'll still enjoy that period. Nothing will go backwards from that period. And we just need to be clear with people what will then happen in terms of any continuing 1987 benefits or any care benefits that they might transition to. Because one of the things I would say I'm really keen to see, because there's so much, I'm going to have a go at building some warmth with the audience, at least at this moment. There's so much talent in that room, and there's so much experience, that the last thing we want to do is see people in haste thinking, I've got my 30 years, I know I've got my benefits, I want to get out the door while it feels secure. I absolutely understand why people might feel that, but think about what everyone in the superintending ranks late in service has got to offer. So we're really keen that those people in particular don't make hasty decisions. The people from 25 years onwards, actually, as a group, don't make hasty decisions, because, you know, there is no question that they represent the backbone of the leadership of the service.
Dan, you've got a question.
Thank you. You know, it's just the explanation Claire gave there is one I've read many times, and it's a narrative that's been produced by the Treasury. What actually happened was the government found that there was age discrimination. The courts didn't say how it had to be dealt with, they just said it was age discrimination. The Treasury have decided that the way to deal with it is to remove the protections. There are other options, but they weren't and haven't been considered. So the government have come up with a proposal to remove the discrimination. And actually, if you look at the case law around these things, there is nothing to say that those people who are given protection shouldn't be allowed to keep that protection. So that is part of the ongoing challenge by the association. Thank you.
Thank you, Dan. I don't mind admitting I'm lost now.
You were never
But I am going to carry on. And you're going to love me for this one, Matt. But here's a question. Well, it's basically a statement, and it's quite a popular one. It says, if I want to retire now, who on earth would I go to for official, accurate figures, and who will sort it all out? We also need to recognise that this is far too complicated and way beyond the ability of most people to understand. And I didn't write the last bit, but it is a common theme. So
yeah, sure. So listen, I mean, there's no, we can't answer the questions we can't answer, but. The starting point is do the same thing that you would do now, which is go to your local scheme administrator, get the most accurate information you can. We think that there are probably too many different organisations involved in scheme administration at the moment. I think to Dan's earlier point that it would probably be better over time potentially if we had a nationally managed scheme. We'd be having one conversation, we'd move this quicker. That's not where we are now. Go to your local scheme manager for the best information about your personal circumstances. Go to information which we continue to make the best information we can available to forces pensions teams, so that you can see what the state of the conversations around things like immediate detriment are. And we will, although I don't have a timeline for this, over the next months we will see that online calculator emerging. It won't deal with your personal circumstances down to every variation which can impact on it, but we will start to give some indicative figures. You, I know, are supported by your association. The association, I know, will on occasions identify those people who can give you independent financial advice. And if you wonder whether we are sort of dropping our shoulders on some of the questions we've been asked, the reality is you'll probably find that any independent financial advisor will still say some of these questions are difficult to answer now. But is it difficult to understand? Yes, it absolutely is, and it's made more difficult by the questions not yet answered. So no silver bullet, but your local team, this is, as Dan has pointed out, for the time being, this is the responsibility of your local force, and you should go to your scheme administrator.
Okay. Couple of more comments and questions, actually. This one's for you, Matt. So who's replacing you as NPCC Pay and Pensions Lead? And this is not reflective of anything you've said this afternoon. It is just a general question.
So, for colleagues who don't know, I'm currently sitting in the national lead for counter-terrorism, the role which Neil Basu's vacated while he's leading the Strategic Command course. Suddenly, national security and countering terrorism seems a bit easier after this afternoon. So, I am engaged with Martin in a quest to find colleagues who are happy to step into either one or both of those spaces. On pay, we've got a substantial team that carry on the work. On pensions, Claire's appointment, and I hope you'll agree, I think she's been brilliant this afternoon. Clair is a really important appointment for us. What I have said is that I will continue to provide some custodianship and some oversight on the pensions challenge in particular, because look, as employers, we can't drop this ball, and I won't. So I'm currently going to continue to, I'll mix my metaphors and I'll spin that plate at the same time as the national CT lead. Martin knows well that I'm, casting around to make sure we've got a really high quality colleague to pick up the pay work and then transition the pension work over time. But I wanted to reassure Dan, who I speak to regularly, and wider colleagues that we're not going to drop the ball on this for you. Colleagues are very supportive. We've got two good teams who support me and actually do a lot of the work in the background all the time. And maybe that's an ask if I can point one the other way to our facilitator and say there's 300. If there's 300 of you in your room, maybe you should go back, and if you think you've got a chief who would do this really well, perhaps go back and offer it to them. Probably best you don't mention the last hour to them when you do that.
I should have jumped in there, but he was squirming, and I thought it was nicer to leave him doing that. But the one thing I will say, so Matt is not going to walk away from this. Anyone who worries about that, obviously, we are in the process, and we will get. I'm not going to give you a scoop at the conference, but we will get someone in. And genuinely, all joking aside, I can't overestimate how serious this is for us. It's for us as NPCC. It's for us as the employers as well. And then individually, obviously, about the care for all the people that work for us. So please don't think there is going to be any degradation in what we are doing. Matt's done a brilliant job, but for all the reasons he just said, can't carry on doing that. But we will get a replacement. I'm kind of in the final stages of working that through, and we'll let you know. But we will carry on working in the way that we've been working with both superintendents and the Federation, and SUPOSA, of course, who are the ones that represent the chief officers in this space. OK, we're going to end on an optimistic comment, and it's quite simply not a question. Thanks to Claire for giving us an excellent presentation and having a great grasp of the brief so far in such a short time, one of the clearest ones we've seen. So well done. And ladies and gentlemen, let's thank all of our panel, please. Claire Alcock, Nick Barker, Martin Hewitt and Matt Jukes. Thank you.